Welcome to you. I am Lőrik Balázs, a criminal attorney. I have dealt with criminal law for more than 10 years. In this video, I try to summarize when you need a criminal attorney, what are the tasks and what are the obligations of a criminal attorney. For most people, becoming involved to a criminal procedure is a single, but at least a very rare occurring situation in life. Perhaps that is why most of our clients have very little information about their rights and obligations in a criminal procedure. Especially the suspect or the accused person may feel that a whole state apparatus stands against them in a criminal procedure. And this situation intensifies their feelings of vulnerability. The primary task of a criminal attorney to balance this vulnerable life situation. People need a criminal attorney because the criminal attorney is the only person in a criminal procedure who is obliged to act exclusively in favor of the client. There is no other participant of a criminal procedure like this. The member of the investigating authority, the prosecutor and the judge has totally different tasks. What are the rights of a criminal attorney? The rights and the obligations of a criminal attorney are closely connected, as in some cases the criminal attorney is obliged to exercise his rights. These rights include inter alia the right of presence. The defense attorney is entitled to be present at procedural acts where the accused is entitled to be present. He is allowed to accompany the suspect to the interrogation. What is more, in some cases, he is obliged to do so. After the suspect is interrogated, the defense attorney and the suspect are also entitled to know the documents pursuant to which he was accused. This right can be limited only in certain cases, exceptionally. The defense attorney has the right to obtain data, to collect data during the procedure. This is his obligation at the same time as the defense attorney has to attempt to reveal all the evidences that exculpate the accused or mitigate the liability of the accused. Such evidence in a criminal procedure may be the opinion of an expert or a consultant. The defense attorney is in the position to decide when the involvement of an expert or a consultant is necessary so that the accused can get in the most favorable possible position. Our office also regularly cooperates with experts or consultants. If we deem that the involvement of these professionals may help in defense, we indicate it to our client, and if he agrees, we involve these professionals into the criminal procedure. In the criminal procedure, the defense attorney is entitled to make proposals and remarks in order to promote the conduct of the criminal procedure, attending to the interests of the client. It is also an entitlement of the defense attorney to speak, to read oral pleading in front of the court before passing the judgment. In the oral pleading, the criminal attorney tries to convince the court of passing a judgment which is the most favorable to the client. One of the primary obligations of a criminal attorney is the obligation of keeping the attorney-client privileged information. Everything the client says or makes available to his defense attorney is subject of this obligation of secrecy. The defense attorney is not allowed to tell these things to any other persons, even if the client exempts him from this obligation of secrecy. So this is an absolute obligation of secrecy. When is it worth referring to an attorney? If a criminal procedure is initiated against someone, authorities quite often interrogate him as a suspect within a quite short time. Everything the suspect says at the interrogation can be used against him later, even if it doesn't serve his interests. That is why it's worth communicating to the defense attorney honestly and rendering as much information as possible that may concern defense. The members of the investigating authorities are aware of these circumstances, and they try to induce the client to make testimony more and more. Believe me, it's risky to make a testimony at the first occasion without a defense attorney, and it rarely serves of the interests of the accused. In addition to this, the dominance in headcount at the police may encourage the client to make an ill-considered decision, namely to make a testimony. Therefore, I suggest to all of my clients not to make a testimony without consulting a defense attorney. If a criminal procedure is initiated against you or your family member and you would like to ask the advice of a professional, contact us and make an appointment for consultation. Goodbye.